£223 million, but it's part and parcel of that word that is pre-Brexit, and also to ensure that we use austerity. That's the word, isn't it? Austerity throughout. There's been a significant number of cuts, loads of closures that centralise court work in different provinces. Of course, it's had a huge effect, a huge impact. Defendants travelling lots of distances to get to other courts. Not just defendants, but witnesses, police, the lawyers, magistrates that travel often more than 50 miles to attend a court. Imagine a scenario where they're then deemed failed to attend if they haven't attended, and of course it comes full circle because the taxpayer picks up that bill as well if they're sent to prison. So it's quite an important issue. But just to touch on it very briefly, I don't want to cross over, but it's the drive to ensure that we are digital savvy, digital modernisation of the courts, because there's a huge programme against access to court buildings. So it's a big drive to save money, to make us all digital savvy. About 1.2 billion's worth of digital savvy.
Yeah, I mean, it seems like what we're seeing with universal credit, isn't it? It's all about going online, which we'll be covering later, but go ahead.
Yes, absolutely. And I think there's other things, not only have the court had for some time now video link hearings, but we're all taught to save trees, so that the lawyers are also required now to access digital papers online. There's a big move to ensure that, we're not wasting money. The other thing, of course, there's been a huge impact. It's not just the lawyers, but the magistrates as well. It makes it extremely difficult, of course, to recruit magistrates.
Why is that?
Some will feel that they have to step down or not apply in the first place because they may not get their travel to and from the distances they're asked to travel. Police and the prison delivery services as well also result in increased costs. Again, falls on the taxpayer. But I guess overall a waste of court time, because that's the thing that the courts are designed to try and bring down, wasting court's time, witnesses being not required for ineffective trials, things of that nature.
Yeah. I mean, in terms of obviously, we're looking that the courts are shrinking as time goes on, and we're seeing how there's encouragement towards digitization. But at the same time, we're also seeing a number of cases that are going to court are going down. But I mean, from your experience, why this might be the case?
Well, I think not only is it that ardent desire to save money, but it's also to make us as prosperous going forward, because the means by which we do that is to ensure not only are we digital, but we're catching up with other jurisdictions, court jurisdictions across the globe who are already embracing technology. I'm not just talking about Skyping clients, I'm talking about ensuring that we're keeping pace, so that when we've got new fancy Crown Court buildings, for example, we can have big screens in which officers or witnesses aren't required to give evidence physically in the court building. So they'll be televised sometimes in pre-trial hearings. Of course, defendants aren't produced, so they have video link hearings as well. It's a cost saving, but also it's to streamline all of these processes very carefully.
All right. I mean, clearly we talked about overview of Ministry of Justice and the courts. Now, kind of moving on to kind of money issue really in the context of an individual. I mean, you must deal with lots of cases that are linked with money, where individuals owe money. So, give us a couple of examples where you come across scenarios.
Yeah, a very good question. I think that Ripon here, it's a strange scenario. Often when people are hit with financial penalties as a means of punishment issued by, say, magistrates or even in the Crown Court, it can be for, as you said, driving offences or a mixed bag. So it can be driving offences, fixed penalty notices, TV licences, as you know, is topical because of the over 75s. Absolutely. But sort of leaving that to one side, the court can order things like compensation to an injured party, award costs against you, and of course, if you fail or you default, the word is, the courts can bring you back to court to impose or levy much higher sentences than financial penalties. So it can come full circle. If you don't pay, ultimately the sanction will be things like prison. So there are a number of factors to be considered. At the time it's imposed, you need to ensure, of course, as a defendant, if you're appearing before the courts, that you present all of the available relevant information about your income, your expenditure, savings, things of that nature. Often it's very alien experience. Walking into a court building for a first time offender or a defendant can be not just terrifying, but a scary alien prospect. The courts almost shining a light on your finances, on your means. And it can often lead to a lot of disarray because there are now a lot more unrepresented defendants. So whereas in the past, say, the duty solicitor would pick up a case that would ordinarily require him or her to be involved to make representation, so speak on your behalf to the court. Often now there are cases in which, say, legal aid isn't granted, that's public funding report, but there'll be other scenarios in which, because of the pressures on the court and the court time, they're not prepared, say, sometimes to wait for lawyers to turn up, so they'll want the defendant on their own to explain to the court their current circumstances and their income.
Speaking of legal aid,
Yeah.
so at what point do you actually get legal aid now?
So there's a dual test, often that people may or may not understand, but there is a means inquiry, so an assessment of their financial income and savings and a threshold, and also what's called an interests of justice test. Now, that essentially is the person arguing through their lawyers usually that they need a lawyer, they couldn't be represented, they couldn't be unrepresented rather, they wouldn't be able to just command the appropriate facts or the relevant information before the court. It could be the magistrates or the Crown Court. Now, of course, there's been a spate of things like legal aid cuts over the years. That often makes or takes centre stage in the media, and perhaps doesn't get as much of a light shone on the problems that unrepresented defendants have. But there are, as you've hinted at in your question, a growing number of unrepresented defendants. I'm seeing, certainly myself and colleagues at other firms are seeing, a reduction in legal aid grants. For example, just giving you an example, an isolated example, it's not the case overall. Whereas in the past, a person charged with, say, theft, shoplifting, petty offences, who might have the odd previous conviction before, or have a more entrenched previous conviction or antecedent history, it's called, we're finding that there are...
What's the word?
So in terms of their previous convictions or their antecedent history, so looking at their criminal record of convictions, sometimes we're now seeing cases being rejected, whereas in the past they were being granted. Now, I wouldn't like to isolate any individual cases, but also other matters, other offences like criminal damage, in particular for youth. Oddly enough, we've seen a rise in possession of drug charges where young people under 17 appearing before the youth courts won't really know what to say to the court. They're ill-equipped to deal with not just the fauna of being in court, but saying the right things to youth justices who are specially trained to deal with their hearings. So we've noticed not a gradual decline, but a cut back on some of the things traditionally legal aid, public funding would have been granted for. So I would still urge people to contact their local solicitors, because I think it's absolutely necessary to ensure that you access your local firm of solicitors to ensure that you get representation, whether that's, of course, Thames Magistrates Court or other local courts.
So when you are, let's say, in court yourself as a duty solicitor, so at what point do you know there's the need for me and for my labour?
Yes. So in terms of the duty solicitor being asked, usually by the court legal advisor or the usher, to be involved in a case, say someone is in the cells and the court has previously found or had on record a finding that they have willfully refused or had evidence of willfully not paying court fines or financial orders that might be consolidated. So an offender may have lots of different court files for lots of different fines, compensation, all sorts of things. And at a point in a case where, say, the justices are going to hear a history where there's still a huge outstanding amount of money, I wouldn't put a specific figure on it, but running, say, sometimes into the thousands, where little effort has been made, say, over 6 months or a year plus to do anything about it, sometimes that person will be brought back to court, sometimes in the court cells if there's been a warrant previously for them failing to attend or not responding to a means inquiry. So it is important, I'd say, first off, for people to recognise that if there is a court proceeding or a contact from your local fines officer, to get in touch, try to resolve a repayment schedule. So some sort of agreement of terms where you are repaying what's been agreed. If, however, you fall on a hard time, so hardship, financial hardship, a change in your circumstances, and what that might mean for everyone listening might be loss of livelihood. So your loss of employment, you have had, say, for example, a new baby or something that has changed personally to you that the court weren't aware of at the time they imposed the financial orders, that they should be aware of, then there are ways of bringing that matter back to court, usually with the engagement of a local fines officer. But the magistrates will scrutinise very carefully what has happened happened
All right.
since the imposition of it.
Since you mentioned the fines, obviously, now tell us the due process that the courts follow or the police follows before it gets to court. So what's the due process?
Yeah, I think a lot of people, and I've been asked this a few times, immediately knee-jerk worry that it's bailiff action. They're going to start having items of property lifted. Not always. And when the fines officer will get involved is when there's a marketed clear history that repayment dates or terms haven't been kept to. So a fine defaulter is usually contacted then by the local fine officer, who will say, look, you know, what's happening here? They will be written to, or the phone will be called.
So let's go back a bit more.
Yeah.
Let's say, you know, you're on the street,
Yeah.
you've been nicked by the police.
Yeah.
Oi, you know, here's the end.
Yeah.
So what happened from then on?
So at that particular point, what will usually happen is if there isn't a warrant, a no bail or other warrant requiring you then to be not strong-armed but taken to the court or to the local police station, then it's usually done by agreement where there is a bail warrant where bail is agreed. So there will be a hearing date that's organised in accordance with the court, the local court.
Right.
And if they are produced in custody or not, they agree and they turn up, then they will usually be entitled to see the duty solicitor or seek out a local solicitor and say, this is the history that's developed, what do I do next? And they will then be asked at that point during a means inquiry to either up their repayment terms or keep to repayment terms, because that's going to be very, very important, and to demonstrate that they will keep to those terms. So it's not just hollow that you're going to continue to promise a repayment that's never kept to.
But don't you have like the option also to say, hang on and say, you're saying I ought to be paying, you know, initially you receive it as saying, okay, you owe me money. But does the court give you the option to say, if you want to defend yourself, fill in X, Y, and Z?
Yeah, there will be times when, remember, the courts aren't just going to be looking at prison as a first option. There are a number of obstacles to overcome. When I say obstacles, opportunities, perhaps is the better word, to ensure that there are repayments that are kept to. So the court will scrutinise first your current, what you say is the problems with your current income. There could be debts that have accrued with others, but remember, the court's not going to tolerate, certainly in my experience, you palming off the court debt, or rather the financial orders that have been imposed by a court over and above other debts that you might have accrued. It could be credit cards or any other debt that's accrued. Of course, life can often take over good judgment when it comes to things like court orders, but the court would insist that that's going to be the one thing that might well end up with you being sent to prison. So they will want you to be very sincere in your attempt to reconcile and keep up with payments first. So even before we get to a continued defaulting scenario, so where it, for example, continues, you will be given opportunities often by the court to ensure that you keep up with things like payments or payment terms that you can agree.
So let's say okay, there's been notices served by the police, went to court. Now we've got a court hearing. So what does the defendant expect on that day?
So on that particular day, whether it's with the or through the duty solicitor or not, you'll be invited, well, you'll be asked to complete a means inquiry form, which you'll have to be sort of completing in detail and signing as well. You may well be asked to give evidence of what you've put on the form as well, so the court may want to swear you in to ensure.
What do you mean by evidence? What kind of evidence are we talking about?
So you may need to explain your circumstances from the witness box, and you're usually asked to sort of go through your financial history and what it is that you initially told the court at the time the sentence was imposed, what's changed, and why you haven't kept up with payments. So the court will undertake an examination of the issues, why dates haven't been kept to, or why you haven't set up the repayment term, because often we get people who perhaps rather ostrich-like put their head in the sand and hope the problem will go away. It really does. But that's the moral of that story. Often becomes the court reminding you, with the risk of prison or the threat of prison, and it's not hollow, that the longer you leave it, the risk becomes greater.
So what sort of people do you actually get in court? I mean, there are lots of players out there. So just visualize it for me, who's in there.
So when you get to the courtroom itself, of course, for the person who's completely new to the process, there's a court usher who manages the court list. There's a legal advisor who sits, male or female, in front of the justices, 3 lay magistrates, and the court will usually go in order. Sometimes they will deal with prisoners in the cells, and then they will take the order of events through the court list, and there'll be a prosecuting advocate, often on behalf of the police. But in a means inquiry, it's often the fines officer, the local fines enforcement officer. Yes.
Okay, so you go into court, you have to... Oh, actually, how do they decide how much you pay?
Yeah, so in accordance with your income, of course, because the court also has to have a fair balancing exercise. The courts also won't be keen to set a person up to fail, because if they are in that sort of square one position, they don't want to be repeating that like a revolving door every other week or every other month, because we are often then finding ourselves, people get set up to fail. But we have noticed over the years, in the last few years as well, people have really struggled. And it's not just finances, because finance can, I'm sure you've covered many times on the show, sort of the mental distress. We are getting more and more people coming before the courts struggling with the distress, the psychological barrier that becomes, and it becomes a huge pain threshold. The sheer number of people, I'd say, in the last few years, Ripon, who I've noticed in the cells or attending voluntarily, who are on the verge of breakdown. They are scared about being in the court building, let alone having to face magistrates. We've noticed a rise in people who are agoraphobic, who can't be around people in general, who really struggle to air, they may feel dirty laundry about their finances in public. And these are, of course, open public court hearings.
Absolutely.
So the sheer distress often will lead to panic. So we have had people over the years who collapse in courtrooms, and I'm not trying to scare people, of course, but it's just the distress that's built up like a pressure cooker over time. So when you're having to relive that, whether it's from the dock or next to your advocate, it can be extremely distressing. And I'm not limiting it to a certain class or type of person at all. It's a universal fear. But finances and financial distress, I've noticed certainly, has an absolutely huge, quite debilitating effect on people.
All right. I mean, a couple of times, I'm sure you've come across this, Kamal, you know, a client outside the court, waiting to go into court and telling you, I'm so sorry. There is injustice going on. I'm not the guy. I don't owe the money. What can he or she do? Help me.
Yeah. Again, very true statement. We very often, not just as a person wearing a duty solicitor's hat, will hear renditions of people saying, look, not coping, thought I would have cleared it by now, really tried hard, Mr. Banerjee, what more can I tell the court? I'm back here for the second or third time. I tried really hard to keep to what the court asked and ordered and threatened me I should keep to. So we do hear that sort of dialogue a lot. And I would add to that, actually, that there are people who, again, very sincere, you know, they've had everything that life has thrown at them. It could be a bereavement, it could be a number of other factors. They're about to lose their home, on top of everything else that might have gone wrong in their lives. So you have to employ a sense of empathy. And often, actually, in my experience, magistrates and judges have been extremely empathetic to the sort of scenario that has been presented. It's not just hearing it for the 5th or 10th time. Magistrates and judges will spend time going through the issues carefully. If there's ever a risk of prison, and there is often when we get involved as duty solicitors, they will scrutinise the points very carefully. So don't be afraid that they've heard it all before. They will have done, of course, but your circumstances are individual to you, and the lawyers should be presenting the arguments very neutrally, and of course, often they do in a very passionate manner. They would have done themselves if they were unrepresented.
Now, obviously we covered a great deal about the courts and the due process in court and means hearing and so forth, but what options do courts have to recover the money?
So there's a couple of different things. We've obviously touched on the P word, prison, but there are a number of other things that the courts can do. Of course, allow more time to pay. There are things that involve things like the probation service, unpaid work. There's what's called attachment of earnings orders.
What does that mean?
So in short, this is an analysis of your current income from work. Now, often that will be the problem that's broken the camel's back often, because for people coming before the courts, they've got financial woes themselves. And the attachment of earnings orders aren't based on take-home pay. So it'll rule out immediately people who are self-employed or directors of limited companies because they don't have a regular verifiable take-home pay. Deductions from benefits, perhaps something that's previously been covered, but in any event, you can qualify if you're on income support, income-based job seekers allowance, income-related ESA, that's employment support allowance, pension and universal credit. the deduction rate from the benefit taken at source is £5 per week. For universal credit, it can be up to £25 each week. Now, if it's contribution-based job seekers allowance or contributory ESA employment support allowance, a deduction can be up to 40% of the benefit. So the rules vary somewhat, but they can, as I say, take it from source from your income, from paid employment, or from your benefits. Yeah.
So we talked about attachment from earnings, we talked about benefits.
Yeah.
Oh, how about the draconian word, bailiff?
Yes, it's a subject we may not be able to cover in detail today as such, but in saying that though...
Give us a summary.
Yeah, give you a very brief summary.
Go on. We need that, bailiff, you know, that blade, knock on your door, you know.
So it's only the goods of the person in question who's had the fine, so the fine defaulter themselves. It's not others that are unrelated. And that's a question we get asked a lot about.
Absolutely.
You know, other people, unfortunately, have had their things taken. What on earth? What do? They would then have to go back to court and argue that the wrong things have been taken. Now, mostly nowadays, private firms are used by courts to collect fines. So it means the taking of goods and selling them to pay the value of the fine. It's called a warrant of control without getting too technical, but the bailiff should give 7 clear days notice for the enforcement notice, and it doesn't include, just for people who are listening to this, Sundays, Christmas Day or bank holidays. There are a number of other factors, but a fines officer can be invited to recall the bailiff's warrant as well to the magistrates if the fine defaulter is seen as having a vulnerability. For example, they may be vulnerable because of some physical disability or a mental health issue, but it does need to be supported by a medical condition. So let's not try and hoodwink or not rely on something that's cast iron to prove the position with the fines officer. But what can't the bailiff take is a question we get asked a lot. Certainly there's a number of protected items. They can include, for example, household items for basic needs. Now, I won't go into specifics, but it can incorporate other things, items specific or personal to your work, because obviously it becomes full circle if you can't then do your work in order to pay the financial orders. Items physically used where, if taken, could result in the breach of the peace. So there's a couple of factors that bailiffs and others have to sort of be governed by. But
are they allowed to break into your home?
In certain circumstances, I believe there can be times, but that's where things have gone particularly wrong between you, the bailiffs. Again, it's not something I could cover in much detail today, but there are times at which they can use forceful action. I'll put it that way, forceful action.
That's fine. So, I mean, is there anything else you want to tell us before you go, Kamal?
Only really just that we are going through a very draconian round of things like legal aid and other cuts, and don't be afraid or fearful of still contacting your local advice surgeries, citizens advice bureaus, the legal advice networks, who really cannot be thanked enough for the work, really good grassroots work that they do. I started my life as a young lawyer at the local law centre in Luton. I learnt more in life within a week of being there, grassroots, than I think I've ever done during much of my training. But you get to meet people who have real problems, real issues, and we really can't take that away from the people who work really hard on the ground. I have to say that in my earnestness, that they are often very passionate about the work they do, perhaps largely underpaid. I don't want this to sound like a completely political or apolitical statement, but they do invaluable work where times are very tough, with that A word, austerity.
So with few words, just tell me, if someone has to go to court, what sort of things should that person be aware of?
Yes, so that if you go to court, and I'm a criminal defence lawyer, so if you go to court charged or summoned with a criminal offence, you should by right seek out legal advice, either when you were arrested initially through the duty solicitor scheme, which is a free legal advice scheme which entitles you to free legal advice, but you should also be entitled to see the court duty solicitor if you're charged with an imprisonable offence, and take that opportunity at the first hearing, because they will very often be able to resolve the case, not always, but often at the first hearing, because that's the mental strain, isn't it, Ripon, that they come to court and they don't want the case lasting months at a time, where they're losing sleep even before they got to court.
Well, thank you, Kamal. If you need to get in touch with Kamal, how do we do that, Kamal? Go ahead.
So my firm is SKB Legal. Of course, happy to receive any inquiries or questions. Telephone contact number is 0845 228 2228.
On that note, listeners, I'll take a brief break and then come back and talk about another draconian topic. which is universal credit. There we are.
Thank you.
That's okay.
Great.